Kennedy bar exam lives on. Senator Lee.
Thank you very much, Mr. Chairman. Thanks to all of you for being here. Judge Ali Khan, I'd like to start with you. Tell me in one sentence what a judicial philosophy is. What do you think that means?
I think it's the set of principles that a judge brings with them when they join the bench.
How would you describe yours?
My judicial philosophy has three components, Senator. First, the humility to understand that the judicial role is quite limited. Legislatures enact laws, executives enforce them, but the only role of a judge is to apply the law to the facts of the case before them. Second, to make sure that all parties leave my courtroom feeling like they have been heard, knowing they have been respected, understanding that I have been well prepared and asked good questions. And finally, that I issue opinions that are prompt yet thorough and that are written in such a way that both litigants and pro se parties can understand.
What role should the text play when you're interpreting a provision of the U.S. Constitution or federal law?
The text is primary. You look at the text first. If it is unambiguous, that answers the question. That is well settled Supreme Court precedent.
Where there's ambiguity, what do you look to resolve the ambiguity?
So when there is ambiguity, for example, in a statute, you would look to not just the text but the context. If there were, depending on when the statute was passed, looking at relevant dictionaries from the time to understand the public meaning of the words that were used. Also looking at the way those words are used in analogous statutes from the time. Ultimately, once you've exhausted text, context, history, dictionaries, you can look at canons of construction.
But the effort should involve trying to ascertain the meaning of those words at the time of enactment, if a statute, or at the time of ratification, if a part of the Constitution.
Yes, Senator. That's why you look to contemporaneous dictionary definitions.
Thank you. In 2021, you spoke on a panel at an event, I believe, honoring the 20th anniversary of the founding of the American Constitution Society. And in your remarks, you said, quote, "I've been able to think through my job, to carry out and live some of the values of ACS." Tell me, Judge, how did you carry out and live some of the values of ACS as Solicitor General and now as a judge on the D.C. Court of Appeals?
The values of ACS, as I understood them, were education and mentorship, and I try to carry those out both in my role as an advocate and now as a judge to make sure that I'm speaking to the next generation of lawyers, to make sure that I keep an open mind, stay current on interesting debates, stay current on the current state of the Supreme Court cases so that I can apply them faithfully to the cases that come before me.
Okay. And what other values might you refer to ACS? Are there others other than the ones you've just described?
I understand from Senator Blackburn there's a long mission statement for ACS. My involvement with ACS has always been on these types of panels where we're discussing legal issues, on mentorship events, when I'm speaking to the next generation of lawyers, particularly about opportunities in public service. And then oftentimes ACS and the Federalist Society will pair up at law schools to have different issues sort of aired and debated. I loved doing and going to those events when I was in law school, and I love speaking at those joint events because I think you're really getting a way of understanding the diverse perspectives of the law. I think that makes us all better students of the law. Obviously, as a judge, my role is just to look at the law and the facts and the cases that come before me. But for those that are still in law school, those that are exploring careers in academia and policy, I think these are interesting debates to be having.
Judge Mondlane, what can you tell me in one sentence about removal? Removal in the federal jurisdictional sense of a case filed in state court.
That if a case is filed in state court, at sometimes, senators, that one party will file a motion to remove the case for venue purposes to federal court, particularly with diversity cases. I mean, that was more so my experience with cases that I handled as a trial lawyer in state court, that sometimes lawyers on the other side would file a motion to remove the case to federal court for venue purposes, and then the case would proceed in federal court with diversity jurisdiction.
Right. Judge Oliver, what can you tell me about the Dormant Commerce Clause, what it means, what it stands for?
Thank you for the question, Senator. The Dormant Commerce Clause is considered the opposite side of the coin from the Commerce Clause. It prevents one state for attempting to gain a political economic advantage over another state by burdening that other state in a way that the home state's not burdened.
If it does so intentionally, that's one thing. What if it does so incidentally?
I think if it's incidentally, you might look at the text of the statute and determine it that way. It is part of Congress's
The
ability.
text of the underlying state statute?
Yes, Senator.
So if it's written in facially neutral terms relative to whether it discriminates against interstate commerce, then is there anything left of the Dormant Commerce Clause at that point?
No, I think there's the important factor of intentionality as we're talking about competing economic interests.
Okay. Thank you very much. I see my time's expired.
Thank you, Senator Lee. I want to thank the panelists and all of their family and friends who came in support today. It is interesting when we have